Okay, we're ready to start. Good morning, everyone. I'm Peter Jaffe from Western University and the Center for Research and Education on Violence Against Women and Children. Welcome to our webinar on the impact of COVID-19 on Ontario's court-related services and access to justice for survivors of family violence. If we look at the next slide, just some basic ground rules. First of all, I'll be introducing each of the speakers, starting with Janet Mosher in a moment, and each of them will be introduced in turn. If you look at the next slide, just a reminder that all the attendees are muted. If you're experiencing any issues, please type questions into the chat box. If you have a question for the webinar speakers, you can type into the Q&A box or chat box, and we'll spend some time at the end on questions and answers. There will be an evaluation link in the chat box at the end. There will be a certificate of attendance that will be generated and emailed to you, so some of you can apply for continuing education credits based on the outline and the PowerPoint. We'll leave that to you. Presentation slides and the recording of this webinar will be posted on our website. There's a code of conduct that we've put into the chat function, just to remind people about appropriate conduct during webinars in terms of the normal expectations we would have in terms of respectful dialogue and discussion. The next slide. We're obviously hosting this webinar from London, but we're all over Canada, from coast to coast to coast, and we'd like you to think about the additional lands that you're currently situated on and join us in acknowledging and thanking generations of Indigenous people who've cared for these lands and in celebrating the continued strength and spirit of Indigenous people. The ongoing work to make the promise of truth and reconciliation real in our communities, in particular to bring justice for murdered and missing Indigenous women and girls across the country, should inform our discussions in this webinar and well beyond this webinar. Next slide, please. Our first speaker this morning is Janet Mosher. Welcome, Janet. Janet is the associate professor at Osgoode Hall Law School at York University. She's a co-founder and co-director of the Feminist Advocacy Ending Violence Against Women clinical program in partnership with the Barbara Schleifer Commemorative Clinic. She's a co-investigator in a research project exploring access to justice, barriers experienced by survivors of domestic violence when they must navigate multiple legal systems. And if you haven't read the paper, we'll put a link to it in our chat function. Welcome, Janet, and thank you for being here.
Good morning, everyone, and thank you for that introduction, Peter. It's a real pleasure to participate in today's webinar. I will speak primarily to research undertaken with two of my colleagues, Professor Jennifer Coercion at the University of Calgary and Professor Wanda Weigers at the University of Saskatchewan. In that research, which we completed early last summer, we examined the then available evidence on COVID's impact on gender-based violence and on survivors' access to critical services and supports, including the justice system. As part of that project, we reviewed reported decisions in the period from mid-March to June 1st, 2020 in family, criminal, child welfare, and civil protection matters where an allegation of domestic violence or intimate partner violence had been made. And this review yielded 67 reported decisions. Over the past few weeks, I've done a very quick and by no means comprehensive updating of relevant literature and reported decisions, which I'll speak to in a moment. As academics examining published literature and case law, our entry point for inquiring into what has gone on or is going on in the context of COVID-19 and domestic violence is limited. There's so much more that is known by those on the front lines working with families involved in court proceedings. And so I'm very grateful to be part of a panel whose other members bring precisely that knowledge and expertise. A new slide. Let me begin by highlighting some of the emerging knowledge about COVID-19 and gender-based violence that will no doubt be familiar to many of you. As early as 2014, United Nations Women used the term pandemic to capture the global pervasiveness of violence against women and girls. The term shadow pandemic has been used more recently to capture the notion that there are two global pandemics wreaking havoc on the world at present: COVID-19 and gender-based violence. UN Women and other bodies have expressed concerns arising from the interplay of these two pandemics, highlighting both the increase in gender-based violence, especially intimate partner violence, that is correlated with the COVID-19 pandemic, and also the relative invisibility of the pandemic of gender-based violence, a pandemic worryingly overshadowed and neglected in the wake of COVID-19. The quote on the slide from UN Secretary General Guterres hints at both of these concerns, noting that many women under lockdown face violence where they should be safest. And he goes on to urge all governments to put women's safety first as they respond to the COVID-19 pandemic. As reflected in the UN Special Rapporteur on Women's requests for country reports, putting women's safety first includes ensuring courts remain open and are providing protections and decisions in cases of domestic violence. New slide, please. Early reports regarding increases in gender-based violence surfaced in multiple news reports. The reports were local and often impressionistic, pointing to increases in the number of calls to shelters, domestic violence hotlines, and police services. Since then, in many jurisdictions, researchers have deployed various methodological approaches to capture a more complete and detailed picture. Consistent with these early reports, this research finds increases in both the prevalence and the severity of domestic violence. While the research that examines impacts on the violence experienced by women at the intersections of multiple systems of oppression is limited, that research shows especially acute impacts for Indigenous women, non-status women, women with disabilities, and low-income women. We also know that they have borne a disproportionate burden of COVID-19 in terms of rates of infection and morbidity, and in terms of job loss. Australian research has documented a rise in domestic violence trauma cases in hospital emergency rooms and increases in the severity of physical attacks. And UK research has shown an increase in intimate partner deaths. Given what we know about the correlation between many of the consequences of COVID-19 pandemic, for example, increases in unemployment, heightened stress, alcohol consumption, isolation, the increases in domestic violence and its severity are not unanticipated. It's important to note that the imprint of COVID-19 on families will be felt well beyond the declared end of the COVID-19 pandemic. And this has important implications for family law. So it's not only a question of what we are seeing now, but what we can anticipate materializing in the near future. New slide. I'll say more in a moment about coercive control, but here I simply want to note some of the COVID-19 specific tactics of coercion and control that have been documented in the literature. The particular source I've included on the slide is Australian, but you'll find several of these and other tactics documented elsewhere in the literature, and several of these were present in the family law decisions that we've examined. While many of these tactics are situated in the context of ongoing relationships, should separation occur down the road and these spouses engage in family law processes, these tactics will be relevant to establishing family violence. New slide. As will be obvious, and as my co-panelists will no doubt speak to in a great deal more detail, in the context of COVID-19, access to services for both survivors and perpetrators has been significantly impacted. This ranges from safety planning to counseling, shelters, medical care, and parenting support. Service providers have worked incredibly hard to pivot quickly and safely to primarily or exclusively remote delivery. But the digital divide and or perpetrator surveillance can make it difficult, in some cases impossible, for women to access services. The challenge in accessing services has, of course, significant and negative implications for the safety and well-being of survivors and their children, and as I'll come to shortly, also significant implications for family law proceedings. New slide. I've included here the definition of family violence from the Act to Amend the Divorce Act, which came into effect on March 1st, just over a week ago, and a near identical definition was introduced to the Children's Law Reform Act through the Moving Ontario Family Law Forward Act. What I want to emphasize here is the explicit recognition that family violence includes not only violent or threatening behavior, but also conduct that, quote, constitutes a pattern of coercive and controlling behavior, end quote. Evan Stark, a leading researcher and theorist of coercive control, likens coercive control to conditions of entrapment, and survivors have described coercive control as like living in a cage. Isolation is a key feature, as is the perpetrator's cultivation of their partner's material, social, and functional dependence. Stark also highlights the micro-regulation of gendered performances. Women are threatened, punished, belittled, humiliated for failing to perform as a good wife or good mother. Coercive control, we know, produces high levels of fear and stress and often leads to depression, anxiety, PTSD, and substance abuse. For children, exposure to the toxicity of coercive control can have profoundly negative and serious effects. A new slide, please. I certainly don't mean to suggest that in every case of coercive controlling violence, there's a risk of lethality, but Ontario's Domestic Violence Death Review Committee's identification of the risk factors associated with lethality reveals how important identifying coercive control is, especially in the context of an actual or pending separation, which you'll see is the second most common risk factor. But note from this list several other risk factors that are associated with coercive control, including obsessive behavior, sexual jealousy, threats to kill the victim, attempts to isolate the victim, control of most of the victim's daily activities. And note too that other risk factors are correlated with COVID impacts, unemployment, and excessive alcohol use. Given the increases reported in domestic violence and its severity, the expanded repertoire of COVID-specific forms of coercive control and the duration of various iterations of stay-at-home orders locking women indoors with their perpetrators, we need to be especially concerned about the potential for lethal violence. New slide. Where there is family violence, families are often, as you'll know, not only involved in family law proceedings, but criminal proceedings, child welfare investigations or proceedings, and for some, immigration or refugee law proceedings. These multiple legal domains interact in complex and multifaceted ways. As we might then surmise, COVID's impact on, say, criminal proceedings has ripple effects on family law proceedings. For example, delays in a criminal proceeding may mean that at the time an urgent motion is heard in family law, charges related to domestic violence haven't been dealt with. It's also the case that multiple services are routinely engaged, which we'll hear more about shortly, all of which have been impacted by COVID, and again, with ripple effects on family law proceedings. New slide. So what did our review of family law cases decided in the early weeks of the COVID pandemic reveal? The slide sets out some of the key principles established in two decisions which have been enormously influential, Thomas and Wohleber and Ribeiro and Wright. First, let me speak to the urgency threshold. At the outset of the pandemic, courts quickly moved into triage mode. Effective March 17th, 2020, regular court operations were suspended and only urgent matters were to be heard. Importantly, notices from the court regarding suspension defined urgency to include requests for urgent relief related to the safety of a child or a parent. That included a restraining order, other restrictions on contact between the parties or between a party and a child, or exclusive possession of the home. It also included issues relating to the wrongful removal of a child and dire issues regarding financial circumstances, including the need for a non-depletion order. In Thomas and Wobler, the court emphasized that the urgency requirement must be scrupulously and rigorously enforced. The court noted that the concern must be immediate, serious, definite, material, and clearly particularized. The court also highlighted the responsibility of all participants, including lawyers, to ensure that only the most urgent cases were brought forward. Pamela Cross, the legal director of Luke's Place, upon some weeks after the suspension of court operations, that those who had consulted with a lawyer were wary of proceeding given the urgency threshold imposed by the court, even though they needed a restraining order. Or, as reported in the news in early June 2020, a counsel to the Chief Justice of the Superior Court of Ontario noted that there were fewer motions involving domestic violence brought in the first 3 weeks of June that had been anticipated. Counsel went on to note that while 45% of urgent cases were family and/or child protection matters, only a handful of those urgent cases dealt with the fallout from domestic violence. Clearly, more data are required here, but a concern arises whether the stringency of the test, perhaps together with the layered complications of online proceedings, prevented some of those experiencing family violence from seeking protective relief. In our review of cases, we also raised the question of whether the articulation of the threshold, immediate, serious, definite, was well attuned to capturing instances of coercive control. A long-standing critique of legal decision-making in cases of domestic violence, and indeed one the new legislative reforms seek to address, relates to the tendency to focus on discrete incidents of physical violence with inadequate attention to the tactics and patterns of coercive control. In the urgency cases, as well as cases deciding the substantive issues between the parties, we noted that in many instances, the facts as described referred to various behaviors, including COVID-specific behaviors, which may well have been tactics of coercion or control, but which were not analyzed or strung together within that framework, even if they were characterized by the court as troubling. For example, in one case, the withholding of a child from the mother of on a COVID-related pretext, in which the courts have been very clear, you cannot withhold a child on a COVID-related pretext, but that withholding of the child wasn't connected to other facts in the case that could have been interpreted and analyzed and understood within a framing of coercive control or family violence. Let me speak briefly to a second presumption that all custody and access orders should be complied with. The courts have said all custody and orders should continue and be complied with, those subject to modifications necessary to ensure that all COVID precautions are adhered to, including social distancing. Here too, a question arises as to whether this operated or continues to operate to discourage those experiencing post-separation family violence from seeking changes to orders when safety issues exist for them and their children. Or might they be operating to pressure women to agree to unsafe modifications to ensure COVID precautions are adhered to? No doubt this concern manifests across many different situations, but particularly poignant ones relate to the closure of supervised access centers, as well as the closure of the many public venues where access exchanges occurred pre-pandemic. This raises the possibility that some women have felt pressure to agree to a non-neutral access supervisor or to unsafe locations for access exchanges. Let me then turn to settlement expectations. The expectation that parties ought to try to settle was firmly in place well before COVID-19, but the courts have emphasized that especially now during COVID, cooperation and communication are required, and they have strongly encouraged parties to resolve issues on their own. And certainly in our review of case law, there were a number of instances where judges encouraged conciliation and compromise where mothers had brought forward facts related to family violence. In the consolidated notice to the profession of May 19th, 2020 regarding court operations, parties were strongly encouraged to consider using ministry-funded family mediation services to resolve their family law disputes. For those experiencing family violence and perhaps particularly coercive control, cooperation is more likely to take the form of submission to the perpetrator's demands and may well compromise the safety of women and children. Especially now, some families need greater protection. That is, they need access to court orders that take account of the family violence experienced during COVID-19. While more information is needed here, there is a good indication that there's been a significant increase in mediation and arbitration since mid-March last year. A recent article by a leading Canadian mediator implores the need for screening and monitoring related to domestic violence and power imbalances. And while this advice is very sound, importantly, Australian research highlights the challenges of administering screening tools for family violence online, and where cases are screened in, the challenges of monitoring for power imbalances during a mediation session. Let me just briefly speak to the maximum contact principle, and I know I'm almost out of time. There's no disputing that children's needs are heightened during the pandemic. However, the maximum contact principle has long been of concern in situations of family violence. While the principle urges the maximum contact consistent with the child's best interests, the concern relates to the inadequate attention sometimes paid to the safety of women and children and to the harms of ongoing exposure to family violence, including coercion and control. In many of the cases we reviewed, in determining issues of access, so questions of contact, allegations of domestic violence quickly dropped out of the harm calculus in favor of the balancing of harms associated with potential exposure to COVID-19 and the harms of being denied face-to-face contact with a parent. Final slide. And this I will only touch on very briefly because you will hear much more about this in the coming presentations. There have been, as one would anticipate, many challenges in marshalling evidence necessary to prove domestic violence in the context of COVID-19. And that's had significant implications in a number of respects, including on the outcomes of cases that are adjudicated. So in conclusion, let me just say, if we return to the UN Special Rapporteur on Women's request to offer a view as to whether family courts remained open and were providing protections and decisions in cases of domestic violence, I think we might answer yes, but there are many unanswered questions for which we need some data and analysis. And it's pretty clear that there is room for us to be doing better going forward. And I'll look forward to the opportunity and questions to speak to what some of those opportunities might be. Thank you very much.
Thank you very much, Janet. If we look at the next slide, I will introduce Julie Lee. We have 4 panelists that are each going to present for 10 minutes and really bring both a local and provincial perspective on some of the challenges in terms of providing legal services, counseling services, supervised access, and also programs for abusers. We'll start with Julie. Julie brings considerable experience dealing with marginalized populations and high-risk survivors of family violence. She's involved at the university in terms of being a family law review counsel for community legal services at Western, actively involved in supervising Western clinical law students, and also worked actively as a sole practitioner with an emphasis on family law issues, particularly custody, parenting disputes, and child protection proceedings. Welcome, Julie.
Thank you so much, Peter. Good morning to everybody. I need to start by saying I most humbly emphasize what Peter has said about this being a local perspective. I've looked at the participants. I am so pleased to see such representation from across Canada. I also see a significant representation from my friends at the bar. And indeed, we have some members of the bench that I'm so pleased to see. So most humbly, what I'm offering, and here, of course, as a lawyer is my waiver, this is information that comes directly from our practice at Community Legal Services at Western, which is a legal aid funded organization for the most vulnerable people in our communities. And as a result of that, I am not representative of the heterogeneous and widely diverse practice of family law. So I'm gonna be very clear that that's where we're coming from. I want to say that I don't want to dive into my presentation without acknowledging the law students that are working at our clinic. They number almost 50. They are full-time law students, and they take on, in the most brilliant, careful, humble, inclusive, and intersectional aware way responsibilities for pretty complex matters. And they are yo women and yo men. So I just want to do a yo for them. Okay, I want to give you a brief overview. I've said that our clients are all legally aided or legal aid eligible. What's unique about this legal aid funding is that there's no certificate. In other words, there's not a limit of 10 hours or 12 hours or 19 hours for the work of the family law proceeding. We do as much as we can. I can indicate to you that when we build out a bill of costs on a recent file that involved a great deal of work, our client, their first language was not English. It required a lengthy period of time for interpretation and for listening and for safety assessments and safety actualization. Our work could have been billed out, even discounting for the fact that we're an educational institution, to well over 50 hours for a single urgent motion. 75% of our clients are racialized. All of them are impoverished. If I look at the new and very welcome definition of family violence, I can see plainly that we have representation from situational or what's called common couple conflict or violence. We have representation for resistance-based violence, where one of our clients is herself charged with assault, having been embedded in a long-term situation of coercive control and abuse by her male partner in a cis relationship. We have representation very clearly being not just situational, but at the basis, at the root of a separation, what I'd like to call the volcanic time in potentially a family law case, and certainly in the lives of our clients. And we do have representation of the long-term coercive control impact, which often leads to serial litigation, where one or well, actually 3 or 4 of our clients have been in court for almost a decade, and one more than a decade. I want to acknowledge, before talking about the impacts of the pandemic to the problems before the pandemic, what I need to notice is that before this pandemic, I think every participant, from litigant to social work supports to judges, I know that they very candidly acknowledge this, and lawyers will say that there's been deeply, it's been a deeply, deeply stressed and in some cases extremely ineffective system. Some of the characteristics of that are a chronic and painful disconnect between what a survivor of family violence would be seeking as what's called justice and what justice is actually jurisdictionally available in family court processes. So there's that huge disconnect, and there's still quite a conversation to be had about that. The systemic delays and backlog. I was pleased to attend a town hall with this province's senior family law justice, Her Honor Justice Suzanne Stevenson, and when asked about the backlog, was forthcoming to the extent to which she acknowledged that the previous existing backlog had either doubled and or tripled. At least that's what's set out in the minutes. Complaints about insensitivity pre-exist the pandemic, especially with respect to a lack of trauma-informed engagement, both on a client-lawyer basis as well as in the court itself. The complexity of the paperwork, I akin that to opening an exam when you open a blank family law form and you haven't been in class for the year before the exam. That can be just terrifying. The high cost of representation, serial litigation, as I've indicated, and the fact that most of what I'm dealing with and we're dealing with in family law has to do with children, and that the impact of these court proceedings and the delays on children should not ever be minimized. Okay, I've lost track of time. I had a nice timer on, so I'm quickly moving to the pandemic, the emergency 1 year ago. Of course, we know that all court activities were suspended that famous day in March. Notices to the lawyers, to the profession, to the court offices were coming every couple of days. There were heroes and heroines in the court office. I have 4 minutes, thanks, Pete. Working probably around the clock. I want to acknowledge the work that they were doing. All paper files were no longer accessible, and the court office, given the administration of justice and the Attorney General and its jurisdiction there, and our bench knew that there was an emergency and responded very quickly. With 4 minutes, I'm going to bump up to what we've seen is in, I'm not going to talk about the process in between March and now, except to say that, again, our senior justice well and aptly described this process as struggling to function. So I would ask you to consider what's happened since the pandemic, that we have those activities where the court and those responsible for the administration of justice, the attorneys general, are trying to re-platform and create access to justice and to function, while at the same time looking at the administration of justice and actually all of the problems I've articulated, looking for opportunities to remedy, ameliorate, and to take new ground. What is firmly understood is that there's that the most impoverished, least connected to the state and or finances, and the most isolated have been left in the dust in this pandemic. That's recognized. I hear that from the bench all the time. We need to be pressing our Ministry of the Attorney General in order to, on an emergency basis, do something about people who are left at telephone booths calling in for child protection or have no access through a telephone or a computer screen at all. I will note, as I know I probably have 2 minutes, some positive impact. Triage is being talked about seriously. I would say that triage happens both in terms of the struggle to function, but I would say there's a broader conversation about the need to consider seriously triage in family law on an ongoing basis and to reconstitute our family law system accordingly. I would say there have been brilliant opportunities Interpretation right now for our clients who do not speak English is really accessible on an urgent basis. Yesterday, we did a long triage urgent interview with a client for a first time, 3 hours of the interpreter's time. It was scheduled within 2 days. Before, the interpreter attended, of course, in person, and we may have had to wait 2 weeks for that. I would say that we have the barriers with respect to moms at home with kids. If they have Zoom and they have a tablet, they're able to do this work with us on an ongoing basis. So there's huge opportunities. There are new legislative changes, which I think are real opportunities that may be now starting to fly in formation with the intent that I hear clearly from the bench, less clearly from the government, to remedy what's been a problem for far too long. I need to finish.
Thank you very much, Julie. Just noticing there's a comment in the chat function about recent research being done by Nick Balla and Rachel Birnbaum and Claire Houston. We can post that in the chat function. We look at the next slide. I'll introduce AnnaLise Trudell, who's Manager of Education, Training and Research at Anova. For those of you not familiar with the name, Anova was formerly the London Women's Community House and Sexual Assault Center that combined into one new organization. AnnaLise oversees curriculum development and evaluation of anti-violence programming and is actively involved in professional training, including training with lawyers. Welcome, AnnaLise, and look forward to your comments.
Thank you. So I'm speaking today about the impact of COVID on gender-based violence or violence against women's services, and really quite specifically actually shelter services. Next slide. So a few of the themes that really emerged now a year in, the first one that I'm going to touch on is that there's been a balancing act, and it's been sort of struck differently by different organizations. And that's a balancing between a trauma and violence-informed care approach and the health recommendations, and sort of assessing which risk is larger. So for example, some shelters have decided to stay at full capacity and to perhaps institute some things like curfew and things like minimizing folks being able to leave shelter and trips like that. Some have moved entirely to alternative housing options, so utilizing hotels in order to sort of be able to space folks out, but also noting that those are not high security spaces, so having to do really refined risk assessment in those venues. And so that challenge of figuring out how to hold to health recommendations and how to also hold to what we know is best in terms of trauma and violence-informed care has been a real challenge. Please click. So one of the studies that was done in partnership with Anova, and then we've been a participant in it, is by Dr. Nadine Wathen at Western. And it looked at the use of these hotels and motels through COVID and whether sort of what the impact has been on women and children, on staff and on EDs. So some of the benefits of utilizing them. For women, they noted greater independence. They really preferred the privacy of those spaces. For staff, the ability to serve more women. So as mentioned, this one of those balancing acts. So at Anova, any shared washroom rooms, we then minimized to one room. So if we had not utilized hotels and motels, we would have had to really cut our numbers of folks we served. So by utilizing these other venues, we've been able to keep our numbers up. For EDs, they noted that some women have difficulty following some of those strict guidelines within shelter in terms of the COVID restrictions. And so that alternative housing minimized that. And by that, that's a really important point because those COVID restrictions have been really in some ways triggering for survivors. So they're reminiscent of isolation that abusers have leveraged. They've really having to go into quarantine when you come into shelter. And having folks stay at a distance with significant PPE has really challenged that connection point that is so key to healing. So in some ways, having folks in a hotel or motel has minimized some of that. There were a lot of concerns, though, noted. So for women, difficulty getting the help that they actually needed and wanted, and worrying about, say, missing that daily check-in if they had left their room. And the stress of where the hotel was located or sort of other residents around them. For staff, the inability to make a genuine connection and hard to assess appropriate risk. So those are not high security, as mentioned, and also hotel staff were not trained to support that. So we had to really refine how we do that risk assessment, and it is not appropriate for many women and children to go into a hotel because of that. And EDs also noted, executive directors also noted security concerns, but in a lot of ways, those concerns were also about being able to support our women and children, especially when there's some challenging behavior that's emerging in relation to, say, other residents or sort of property damage, and having to navigate that relationship with hotel providers. Next slide. One other theme that emerged was this bottleneck, or a notion of a bottleneck. And so prior to COVID, there was a bottleneck between exiting shelter and getting housing, be that social housing or other forms of housing. And that really means that kind of determines the length of stay in shelter in sort of a normal course of action. In the context of COVID, that bottleneck has even significantly become more challenging. So that's both for two reasons. One is that the challenge in getting social housing has become greater and more challenging, but also we have, for many shelters across the province, fewer beds to offer. And that's back to that balancing act of how many beds and what kind of health protocols are we trying to navigate in that. And so for Anova, for example, what that's meant is that the length of stay this past year was up on average 71 days. That's quite a bit. And that really means that for every day that a woman stays longer, that's a day less that we can serve someone else. And so the number of times that we had to turn a woman away who called our shelter was up, and it represented 28% of our calls in 2020. Click, please. Can you go back a slide? There was something that was supposed to pop up, but it didn't. So I'll just speak to the image that you see there. It was also part of Dr. Nadine Wathen's study, and it was looking at the impact on shelters of having to institute different types of quarantine protocols. And it was really, I won't dive too deeply, but it was really important to look at, because what it showed us was we lost about 27% on average of our space usage across the province in terms of our shelters. So the first rung is sort of shelter used in normal times, and orange represents primary space, which is bedrooms and washrooms, and gray is representing secondary space, so communal space, children's space, and eating space. Physical distancing protocols, so the dark blue is where we increase cleaning. And then at the bottom rung is when we have quarantine protocols in place. The dark gray is the space that we closed off. And so you can see one of the bedrooms, 1 out of 4 in this particular example, was closed. All of the communal space was closed. And so not only does that have a bottleneck in the sense of how many folks we can serve in that shelter, but it also completely shifted how we're able to serve them. We're not able to sort of gather for meals. Meals are isolated into their own rooms in many circumstances. So the layer upon layer of isolation and distancing has been really challenging to navigate. Next slide. I would be remiss if I didn't also point out the impact on staff and volunteers in this sector. We were part of running a national survey almost a year ago at this point, asking staff within the sector about the impact of COVID. And one of the sort of startling stats that emerged out of that was that 81% had noted work-related stress was significantly or somewhat more than it had been prior to the pandemic. Now, if you're not sort of working in a shelter context, that might not seem that surprising. I think we've all seen an increase in stress during COVID. What's I think specific to the sector is that this sector at the best of times is a really stressful sort of space. So you show up to work at a shelter, and from one moment to the next, you might have violent behavior emerge where you're having to employ de-escalation tactics. You may have to engage the police to come into shelter. You might get a phone call that someone, sort of their children and them, need to escape right in that moment. You don't know what your day is going to face, and your day is inherently going to face stress at the best of times. So to see an 81% increase was pretty startling and significant, and that's a big burden to carry. And I think part of the unsort of spoken part of this was also folks working at home, doing counseling work in particular. And this quote has stuck with me for months. Working for survivors of sexual abuse, you hear a lot of horrible stories every day. And since COVID hit, I had to invite those stories into my home. My entire living space has been slimed with stories of sexual violence, making it hard to leave work at work. I think about them more often. I feel like I can't escape. It isn't like working from home for lots of us. Doing counseling in your own space is incredibly challenging and perhaps even triggering to your own experiences. So that's an important thing to note on the sector. If you'd like to know more, that report can be found on our website as well. Thank you.
Thank you, AnnaLise. We're going to now turn to Tim Kelly. And again, I just want to say that all of the presenters could have managed a 3-hour presentation just by themselves. So trying to get people doing this work down to 10 minutes is difficult, but I appreciate your support. Tim comes to us with lots of experience as Executive Director of Changing Ways, London, Middlesex, Chatham, and St. Thomas, Elgin County, co-developer and trainer for Caring Dads, a program helping fathers after violence, which has been a critical program in our community. And we've asked him to address some of the challenges in trying to help abusers change with the new COVID environment and trying to do things through Zoom and other formats. Tim, over to you.
Okay, thanks, Peter, and hello to everyone who's out there. Really appreciate the opportunity to have this talk and present what we've been doing. What I'm really going to focus on in this talk is specific the partner assault response programs, and those are the court-based programs to intervene with men who cause harm in their families in Ontario specific. Although the sort of challenges that I'm going to talk about, we saw through our conversations with our partners from around the world and across Canada and the United States as well. Anyways, the other piece that I do, which for the last 2 years, I've been on a secondment, a half-time secondment with the Oxford Children's Aid Society, managing the family service counseling program that's embedded within the Children's Aid Society in Oxford. So that program offers PAR programming, offers court support work. There's a variety of different aspects to it. So it's given me this sort of interesting view into the sort of intersection between, you know, what's been happening in child welfare, what's been happening in the criminal justice court and family courts. Next, please. What we realized really early on in this was we needed to shift pretty quickly and try to figure out how to support the men that we're working with. So I'm talking specifically about cisgendered men in cis relationships in this particular talk. But what we realized, we were no longer going to be targeting behavior change, and our goal really began to focus on risk, understanding risk, and trying to impact risk as much as possible. So refocusing on monitoring risk and addressing the immediate needs that are related to that. So how we did that was initially, before we were really puzzling through for a month or so in terms of how to do sort of virtual meetings. There was a lot of debate amongst members of the PAR Alliance and in Ontario as well as others. But the safety, the concerns, the dangerousness of doing Zoom meetings. But what we ended up doing was increase our contact with the men that were sent to us, as well as significantly increase our outreach to the survivor partner victims that were there. And really what we were trying to do was get in front of what we were seeing in sort of real time, this huge shift in dynamic risks that were taking place within the families that we work with. So whether the families were intact and living with the perpetrator in the family, or they were separated and the issues that were happening related to those separations, and the isolation has been identified a number of the sort of risk factors that we were attending to at the same time as we were also trying to figure out, how do we do this work? And, early on in this, there was, we made a number of outreaches to the Attorney General's office on what their direction, what their suggestions were. And it was a challenge to get any sort of communication back from them early on in what we're to do. So we're really at this point, so I'm talking about March into early April, towards the end of April, we were really trying to sort this out on the fly as we were going forward. Next slide, please. So how we adjusted the work, and I talked a little bit about that, but I think what was important for us to figure out, a way of monitoring. So when we had them in our groups, they would come in weekly into the group. There was a process of both monitoring and working towards change. This became really monitoring risk and working towards that. So with in the two agencies that I work in, what we started to do was make a mandatory call in from the men. So they were scheduled to call in. They would spend a significant amount of time with the counselors, going through identifying risk, working on safety plans to keep everyone in their life safe. And while those phone calls were happening, we were able to schedule those. The partner contact were able to also follow up. So we identified key dynamic risks for reassault, and those were the sort of areas that we saw as really vulnerable at this point in time that we would start targeting and looking at. And Janet Mosher identified a number of those risk factors in her presentation that we were all really becoming quite aware of what that meant in terms of the lockdown that was happening. And we wanted to work with the men to help them understand the risks they were posing to others. And what we were able to do, even though we were all kind of moving into this virtual, was look at ways of collaborating differently with other social services and managing to reduce the risks. And one of the, in the Oxford County area, an example that I can talk about really briefly was we had a number of men who were significantly unhoused at the time. They were living in their car. They were unable to go home because of the conditions of the court, and family members, because of the kinds of restrictions, weren't taking these men in. So we had a number of men that were sleeping rough or sleeping in cars, and it became quite a significant issue for us. And so we were able to bring together in a number of occasions in Oxford a situation table meeting virtually, where we identified the risks that were there and had other service providers able to kind of come around them and really this was a focus on reducing risk. So what we were able to do then is provide, really immediate and practical support to change that. And so when I talked earlier, the slide before, our sort of focus in doing this work moved from, really targeting behavioral change tactics and working with men to really just in the moment right now in this time, focusing on those risk factors that were there. Next slide, please. So we developed some principles for us to work with. So I want to kind of talk about where the sort of places that this took place in the PAR world in Ontario. There are three basic organizations that have membership of PAR programs. The PAR Alliance, which has roughly 35 member agencies involved with that. There's Family Service Ontario, and then John Howard Society. So we began to look at, sort of direction in terms of how do we provide sort of some guiding principles, and developed those principles to help guide decision making. So response to COVID, looking at the safety of victims, partners, or survivors became not only a paramount focus of what we did. It's always a part of what we've been doing, but it became the focus of the work for us. So the program changed to inform that sort of safety, and not to necessarily expedite what's going on in the criminal justice system. So as we were trying to figure these pieces out, what we were experiencing from the criminal justice system in all of our communities was this scramble to figure out how to deal with cases as they were coming up in the courts. I could talk for another hour and a half on what that interface was like for us. But what we ended up doing was developing risk assessments and risk management strategies and ways of engaging with men using lethality and risk assessments to identify those things. And then what we also, again, as I said earlier, really began to develop these much stronger relationships with our communities that would provide other kinds of supports while we were working with him. Next. So where we landed after about a month and a half of doing individual focus was a number of us started to experiment a bit with virtual groups. And what we wanted to do was try to figure out what those groups look like. I got a minute left, Peter. Oh my God, that was fast. Okay, so what we did with virtual groups with men who didn't have access to technology, we were able to use some additional funds that we received from the government by this time to purchase some basic throwaway tablets, and we provided those for the men who couldn't access who didn't have access at home for that. We set up a number of sort of conditions for providing that safely in a home. And if those conditions weren't able to be met, then we continued to do an individual supervision with them. We limited the groups to 8 participants in a Zoom setting, and we limited it to 1-hour sessions with then a 1-hour follow-up. And then sort of minimum ongoing contact in addition to the groups with the men. And really, again, the focus was trying to manage and maintain some safety in terms of what was happening for them. Next slide. Right. So in terms of the outreach, the partner contact work, there was an immediate recognition of the risks. And many of them were, as Janet identified, were living in the home with the offender that was there, and they were quarantined to be there. We understood that sort of risk that was happening there, so we changed our protocols and our work with them, increased the contact and made it a 2-way contact for the women to reach out when that was available. And these, for many of the partner survivors, this became through this period and is ongoing even now, a fairly significant lifeline to an outside person that had a reason to have that contact with them. Next, I think that should be almost done. Yeah, so I kind of talked a bit about this, where we did the regular check-ins, we did Zoom meetings, and we're still doing that work right now, and we're trying to figure out how we're kind of transitioning perhaps back to in-person. So I just got the cane thrown at me from Peter to wrap up. So I will end now on that. Thanks.
Thanks, Tim, and we'll get back to your question period, because I know there are lots of questions that are going to arise from the presentations. Last but not least, Amanda Bruyns. Obviously, children are often an afterthought in many of these proceedings, but obviously a critical resource are supervised access programs. Amanda is a program coordinator for Merrymount Children's Services in London, and she assists families who are going through separation, divorce, who are often court ordered to have supervised access. So Amanda, over to you.
Thank you so much. I will speak to the challenges that supervised access has had providing safety in family violence cases. So just going to provide a little bit of background information about the supervised access program. So in 1992, the supervised access program began as a pilot project with ministry-funded centers in 14 court districts across Ontario. Court districts included and are still active today. So those include Belleville, Brantford, Cornwall, Durham, Kitchener, London, Midland, North Bay, Peel, Rainy River, Sault Ste. Marie, Toronto, Windsor, and York. So those were the main pilot project locations. So after successful review of the pilot in 1994, the supervised access program was granted full program status and became a permanent part of the Ministry of the Attorney General. From 2000 to 2003, there was a significant expansion. The program became province-wide, available in all 52 court districts across Ontario. In 2021, there was program database development, and it launched to become technology enabled. In 2008, the program funded doubled, allowing for full province-wide expansion. All satellite locations became full centers. Many centers expanded their sites, hours, and staffing. In 2018, there was a launch of a new, more accessible database. And then in 2020, the program shifted divisions within the Ministry of the Attorney General. So now we are under the Victim Services Ontario with a regional approach. Next slide, please. On March 17th, 2020, we ended up stopping providing the in-person services to families in our program due to the pandemic. So clients that were already utilizing the program were informed that in-person services would be reevaluated at the beginning of April. Then in May, clients were told that no in-person services were being offered at that time, and they would be contacted once in-person services were able to resume. Clients already utilizing the program were offered virtual access, which included monitored email correspondence, monitored phone access, and monitored video access. So coordinators across Ontario were searching and testing different platforms to use to facilitate parenting time appointments, as limited centers were offering virtual type access prior to the pandemic. So arranging technology and devices, training for staff, electronic note-taking were amongst the challenges at that time. There was many considerations provided and given for facilitating virtual access where domestic violence presented in those situations. They required specific attention, such as the residential parent may have had concerns of hearing the non-residential parent's voice in their home during parent-child contact. The residential parent thought that the non-residential parent would get their contact information. Bail and no contact order restrictions limited parent-child contact. Residential and non-residential parents were concerned of being recorded during the parent-child contact, and at times children were too young to participate in the access on their own, needing the assistance of another adult, which typically wasn't suitable. So other challenges included clients that may not have had access to internet, no access to an electronic device, and or not enough minutes on their phone to have this facilitated. The safety measures that were taken with staff and clients if the connection was interrupted during those access appointments, and just about in London specifically, there was less than a handful of families used the virtual access options. So we found that due to issues relating to domestic violence, most families were not suitable for this type of access due to current no contact conditions. One parent may have agreed to the virtual access, but the other parent was not agreeable due to the conflict that was present in that situation. The program was closed for the in-person services, and while this was taking place, some families facilitated their own virtual access on their own. So that would have been either through FaceTime, game chats, and exchange transfers facilitated in the community. Some successes with offering virtual access, it was a reduction of barriers associated with transportation for clients getting to the access centers, inclement weather closures, sickness, children with specific behavioral and or medical needs, child-adult mental health concerns, and hearing and speech impairment. Some coordinators across the province did start to see the courts ordering or parent time agreements indicating that both in-person and virtual options at that time would be for those specific cases because of ongoing pandemic-related disruption to parent-child contact. Next slide, please. So in terms of the in-person services, the London site resumed in-person supervised exchange transfers first, and that took place in July 2020. In-person supervised parenting time resumed September 2020, and then we resumed accepting new referrals in October of 2020. So our site remains available for in-person services, and there's limited availability to facilitate virtual access for families experiencing barriers with in-person. And that could be relating to medical issues, preventing masking, the non-residential party resides outside of the country and unable to cross the border. Some challenges that have been experienced with providing in-person services across the province. Some access centers are located in childcare settings, and they've been closed on and off during the pandemic, so they may have not been able to go into their office space and then not able to reopen for in-person services. There's been much varied information provided by the different public health units across the province, and this has really played a part with some centers not being able to provide in-person services. The group setting and physical distancing restrictions continue to pose challenges with in-person services. We have challenges relating to costs to reopening safely, providing PPE, disinfecting, sanitizing, air purification in on-site access spaces. There's also been the need for increased staffing needs to operate the program with all these challenges. Issues that continue to pose challenges at the time of in-person parenting appointments is gift giving at the time of the on-site parent-child contact, food being brought into the access center, guests attending the supervised parenting time appointments, items passed between household, masking, sharing of affection during parent-child contact. We continue to have some challenges with the staff responding to clients who are increasingly isolated, many of whom already struggled with addiction and mental health issues, of course, including issues related to domestic violence and stresses of job loss. So in London, the current supervised parenting time appointments are limited to 1 hour opposed to 2 hours every other week. So that's been a major reduction in services that we're able to offer to families. There's a limited number of exchange transfers at one time that we're able to facilitate, and this has led to shortened off-site parenting time. We have seen an increase of anxieties that parents have had that this may be portrayed onto their child or children, and this has contributed to children attending off-site parenting time arrangements. We continue to support the children and parents during these times with their concerns of COVID-19 guidelines. When our families resumed services, numerous parents had not seen their children for months, which has led to a reintroduction type of parent-child contact. Some children did not want to share any physical contact with their non-residential parent any longer. Children did not want to sit near them, citing they had to be 6 feet apart. Children questioned their non-residential parent and if they were practicing proper COVID-19 guidelines. Families who had supervised exchange transfers were left with nowhere to spend time together, as many establishments were closed due to the local COVID-19 restrictions. We've seen residential parents not agreeable to continue with parenting time arrangements due to non-residential parents potentially coming from a hotspot area. We have seen many families whom were scheduled for settlement conference, family and or court dates, trials, which they have experienced many delays in accessing justice. Families have tried to make parenting time arrangements work on their own in the community as we're starting to receive new referrals into the program. Unfortunately, this has led to children witnessing the conflict between their parents at the time of access arrangements and at times witnessing abusive situations and or police involvement. So the program continues to manage day to day with the ongoing needs to be flexible. Thank you. And I just included the contact information for myself on the last slide.
Thank you very much, Amanda. Again, I appreciate everyone presenting in such a tight time frame, and we have lots of great questions. So if I could ask the panelists to put on their video and ready to unmute themselves. I guess let me just, and there's questions for everyone. Let me just throw a question, Tim and AnnaLise, is there any emerging research or things that you're aware of that talks about the difference between counseling in person or counseling by phone or video, or if there's not research, do you have a sense of, from your experience, about effectiveness? Are we, And at least maybe start with you. Any impressions from your staff about effectiveness online and phone versus in person?
That was one of the themes that emerged out of that national survey that was done and continues to be something that is present for our staff. It does increase access for some clients. So for some clients, this has been really beneficial, actually. It's sort of forced us into a change in a positive way. So that might be because of transportation issues, that might be because of ability issues, but also just the convenience and the privacy of their own home rather than coming into a building that is sort of publicly stated as such. However, for a lot of the more obvious reasons, it's been a barrier. So being able to do counseling in a home where your abuser's 2 rooms over, or your children, and you're trying to manage that, and technological challenges. So but I think presuming that it is only one or the other is false. It's presented both positives and negatives.
Tim, any brief thoughts on that?
Yeah. So in terms of what we ended up doing and refocusing the work, we focused on targeting risk factors and working with that. So we do have some, and that was, you know, making those decisions was based on some earlier research that we've done with Dr. Scott, Katrina Scott at the center now, looking at dynamic risk factors and how to work that, how to focus those. So we did some work on that. And that kind of, it was the basis of that research that helped us develop this sort of strategy going forward with this. The upside of this, and I'll echo what AnnaLise said, was what we saw was a real shift in access, where we had men who were much more rural and had transportation issues. If they were able to actually get access through a phone or through a Wi-Fi, then we were seeing them a lot quicker coming into the program. But again, I want to reiterate, we weren't really targeting behavior change as much as we were targeting safety and looking at risk, the implications of risk related to what was happening there. So I saw that question come up. I texted Katrina in the middle of it. She said that sounds like a really good research study to come up once we find some air to get out on this. So.
Sounds good. And also a good reminder from both of your comments that there's lots of research with trying to provide services in rural, remote northern areas where this is sort of a reality and parallels in some of the COVID experiences. And so there's some tricky legal issues, so I'll get Julie and Janet will need to help us on these. There's a question about how to put secondary source evidence about violence before a court on interim motions. Julie, does that question make sense to you?
Yes, I'm not surprised by the question. I know that Professor Mosher's paper, there was a lot of focus on the urgent motions that cascaded or didn't cascade after the beginning of the pandemic. My response or my thinking about that as somebody in practice is to really understand how temporary those orders are. The urgent motion is never going to be defining what the final outcome is going to be, especially given the pre-existing law and the fact and the very nature of what a temporary order is, and the law reining in what can be decided on affidavit evidence, which is the stuff of a temporary or urgent motion, and what needs to be decided on the more substantial in-person or viva voce evidence. So the evidence that needs to be before the court, there were limits because the court itself was desperately trying to control the paper coming to the overwhelmed people who are judges and trial coordinators and office people. They really wanted to target as efficiently as possible because that's one urgent motion was matched by another 25. So they tried to focus it. Now, having said that, if there was evidence, and I worked on some urgent motions in the beginning of the waves, the first wave, that evidence should be corroborative evidence. It should be doctors or a third person's evidence, some sort of professional working with the child. It depends on the order being sought, okay? I can't say, like, we don't know what orders were being sought. I think that restraining orders were going ahead, but not as many as we thought would occur. But then there was a lot of motions about parenting arrangements, and the status quo had to be examined, and the risks, there needed to be good evidence in affidavit form. Am I helping with that, or just confusing it more?
Helps me, but I'm not a lawyer. So, Janet, anything to add to that, or I'm happy to move on to the next question?
Yeah, only just to add very briefly, I think one of the challenges too was, and continues to be, how one actually gets the kind of cooperative evidence that is important often in these cases, especially where there's an allegation of domestic violence, because it's often met with an absolute denial, or it's met with a refutation, which is actually, I am the victim. And so you often have competing affidavit evidence, and other sources of potentially corroborative evidence is really important. And I think this is a challenge generally in cases involving allegations of domestic violence, heightened during the pandemic, because being able to access things like medical records, or a complete child welfare investigation, or a report from the Office of the Children's Lawyer, all made much more difficult, and often longer delays. And I think the longer delays in getting to a final adjudication, if it's at a trial or a summary judgment motion, is also important, because it means that there's a status quo that exists for a longer period of time, and that will be relevant to the ultimate determination too. So I will leave it at that, and we're time for other questions.
Can I just add one thing, that a lot of people that we were seeing desperate about these issues, and recognizing the barriers around working with agencies to get third-person documents, started to resort, and I'm very concerned about this, to social media and videotaping children, which is, from my point of view, an outrageously inappropriate thing to be doing. So people who are desperate, and we are people struggling, we're doing inappropriate things. And given the pivot, oh, I hate that word so much, the pivot to technology, it started to focus and pierce any kind of boundaries that we need around our kids. So I just want to flag that that may be a problem as well.
Okay. There's a related question, and that's the pressure on settlement. And particularly there's a question about the increasing and pressure to be involved in family court settlement conferences. Janet and Julie, any thoughts? I mean, it's a general thing that you hear from many survivors, that, you know, when there's difficulty accessing courts, and also, you know, accessing proper representation, there's a pressure to settle. Is that an issue you're seeing?
I don't like the word pressure to settle. I think that family law litigants should be really seriously thinking about resolving these issues in or out of court. If you're in court, it means that you still have an opportunity to resolve it, as long as we take seriously the risk. And I think that a professional, family law professional, should never, ever be looking at terms for settlement or for mediation without taking that seriously. But I'm in the crowd that firmly believes that there needs to be reasonable resolutions, and there may be there's way too many situations where the litigation itself, without settling, just creates impossible situations for both mom and dad in a situation, and also for the children. So pressure is not okay. That's not serving somebody's needs. But seriously, returning to that question is important, and giving options are as well.
Janet, any thoughts? And again, not using the appropriate pressure, but were the risks present with family violence may be minimized in order to find a settlement?
Yeah, so I also want to respond. Someone helpfully posted into the comment as well that the May 19th directive from the courts that included information about access to mediation services, it did indicate where mediation is appropriate. And where mediation is appropriate is a question that I think has been debated for decades now, actually. And there are real concerns about the appropriateness of mediation in cases where you have significant inequalities of power. And I think related to that, some really significant concerns where what has characterized the relationship to date is coercive control. And we do have a huge body of research now trying to evaluate the efficacy of different kinds of screening tools. And I think that research has progressed us in significant ways, but we're still, it's certainly not, we don't have any kind of perfect tools, but how well are mediators trained in those tools and how commonly are they used, I think is an open question. And then inside of the mediation process, even if you've decided something should be screened in, how effective are strategies to address inequalities of power inside of the mediation process? So it's absolutely true that litigation can be enormously problematic when deployed at the hands of a coercive controller. We know about litigation stalking and abuse. So it's not as though litigation presents necessarily a wonderful answer for women who are survivors of abuse, but it does require that I think all lawyers and mediators and judges, everybody who's participating in helping families come to a safe resolution, have a really in-depth understanding of domestic violence, its dynamics, its consequences, etc. So yeah, there's not an easy solution here, but knowledge is really important.
Okay. Just one last legal question, that's a theme about the impact on support payments. Obviously, COVID, has had a dramatic impact on jobs, and therefore an issue around appropriate level of support payments, and again, potentially trying to find resolution in very difficult times. Julie, any thoughts about?
Me and my amazing student team have just recently researched the issue of the impact of COVID on obligations to pay child support. The CRB has not been ruled, and there's one or two cases as not income. It is an income replacement, and it's seen by the court that made these decisions. So the obligation to pay child support if the income is replaced income remains. The law with respect to determining how much it should be remains something that is set out in the child support guidelines. I'm of the school that the guidelines are there. They're going to be referred to by the court and or other authorities. Mediating or negotiating child support, that should have gone away a long time ago, because these the federal child support guidelines are there, and they're there for a reason, and they're rationalized, I think, quite appropriately. If there's specific circumstances related to income, etc., those, in all of these cases, it's always nuanced by what the individual circumstances are, but generally, the guideline table applies.
Just a couple of questions about supervised access. So Amanda, and you might want to pass on this question, was there any discussion about supervised access being seen as an essential service prior to the shutdown?
That question come in, and so I was kind of pondering that question, and I don't think we questioned the essential service of supervised access, that we never questioned that it was not essential prior to this pandemic. It definitely, in our communication with our local health units across Ontario, we were definitely put in a position to advocate on behalf of the supervised access program. And we wanted to deem it essential so that we were able to continue providing in-person services.
Okay, this may be a question for your AnnaLise and Amanda. Are you seeing cases where if supervised access isn't available in the form that people require, they have to decide either unsupervised or no access, which would be obviously a dilemma, both for the courts and the parents? AnnaLise, any cases you're seeing through Anova in terms of people being asked to compromise about unsafe access arrangements?
No, and we would really refer to our colleagues at Merrymount and folks who specialize in that.
Amanda, are you ever between a rock and a hard place where you're in the middle of a discussion where it's either no access or something that makes you nervous?
I think the I'm going to label that as anxieties that parents have felt with in-person services has escalated. but I know we've had some referrals and across Ontario from areas that are not open for in-person services for supervised access, and those cases being referred out of those court districts. So to the access centers that are open for in-person.
Okay. I'm seeing that it's noontime, so we should wrap up. There's a evaluation link that you can see and complete. We're going to distribute a recording. We'll post a recording of this session. And also we may call on the panelists to try to answer questions. We may circulate questions that we can post more complete answers to the extent that those answers are possible. I want to thank Amanda and Tim, Julie, Janet, and AnnaLise for working within very tight timeframes. I think it's been a really very helpful and rich discussion, and obviously one that if we had all day or 2 days in a row, we would certainly keep going, because there's lots of obviously controversial issues. So thank you for your contribution. And I think, the pandemic is not going away quickly. I think we're all optimistic that we'll all be vaccinated by the fall. And if all goes well with the supplies, especially the older professors who are most in need. But certainly the pandemic will continue in one form or another, with obviously concern about variants. And even when it's over for some people, there'll continue to be anxiety. So I think one of the things that we're all looking forward to seeing, whether some of the new things we learned will continue as new practices. And so many people may find the innovations will carry on. So thank you all for attending, and thank you for participants for your comments and questions. And to the panelists, we'll have a separate Zoom link if we want to debrief for a few minutes. It'll be emailed to you if you have time to join for a separate Zoom meeting. Otherwise, thank you all very much, and have a good rest of the day.